Kidogo tu. Okay. Kapo.
Ukiwa ready. Hapana. Recording sasa ndo nimebosa.
Morning, everyone.
Good morning, all. Welcome to today's court before Honorable Justice Bahar Mwangaza. My name is Herman for the assistant. The matter coming up for judgment is Petition E for 29 of 2024. Honorable Kawira, Mwangaza, by the Speaker of the Senate of Kenya and others.
Thank you. Who's in the matter?
Good morning, Your Lordship.
Good morning.
The matter, my name is Elias Mutuma. I appear alongside my learned senior Mr. Elisha Omboya, who is in the Great Camp. I also appear alongside Robert Mutembei.
Yes.
Frida Kimathi.
And Frida?
Frida Kimathi.
Frida Kimathi.
That is all for the petition.
Thank you.
Good morning, my lord.
Good morning.
Kanji,
Yes.
for the respondent.
Thank you.
Good morning, my lord.
Good morning.
My name is Boniface Morero.
Yes.
I appear for the fifth interested party. My colleagues, I also want to brief for Mr. Kiremi for the third interested party. He's on his way to the court.
Yes.
Benson Kenya appears for the fourth interested party, is present. And Mr. Eric Muriuki appears for the fifth interested party, for the sixth interested party.
Benson Kenya for the?
For the fourth interested party, that is Speaker.
Yes.
And Eric Muriuki for the 6th interested party.
Good morning, my lord.
Good morning.
That matter, my name is Lawi. I appear alongside Ms. Mwangaza, who's present in court.
Yes.
For the first interested party. Counsel without us.
Thank you.
Most praising judge.
Yes, good
Mrs.
morning.
Omondi.
Yes.
I appear alongside Ms. Kawira, who is present in court, holding brief for Ms. Eunice Malas, to record USA Kenyans, the second interested party.
Thank you.
Good morning, my lord.
Good morning.
Designing Jamway for the seventh interested party.
Thank you. So the judgment in this matter is ready. We have also prepared a media summary, which I will release at the conclusion of reading the judgment. We have 2 hard copies that I will also release to the parties, one side to the petitioner and one to the respondent. So I'll begin reading. It's 50 pages, bear with me, it'll be quite long. The petitioner herein filed a petition dated 21st August 2024 and thereafter, with the leave of the court, an amended petition dated 23rd December 2024 seeking the following orders. A declaration that the refusal, failure and neglect of the respondent to make a ruling on the question of whether the Senate could debate and make a resolution on a motion involving matters actively pending before a court of law, including an order halting the impeachment process of the petitioner, was arbitrary, high-handed, unlawful, and a violation of the constitutional principles of constitutionalism and the rule of law. B, a declaration that the respondent's conduct and management of the proceedings culminating into the resolution to remove the petitioner from office by way of impeachment was in violation of the petitioner's right to fair hearing as guaranteed under Article 50, Clause 1 of the Constitution of Kenya. C, a declaration that the actions of the respondent to allow voting on the motion for removal of the petitioner from office on 21st August 2024, a day not gazetted as a sitting of the Senate, contravenes its constitutional mandate, hence the resultant resolution to remove the petitioner by way of impeachment emanating from the proceedings of 21st August 2024 is ultra vires, in law, thus null and void. D, a declaration that failure to conclude the business culminating into the resolution to remove the petitioner from office as Governor of Meru County on 20th August 2024, as gazetted vide Gazette Notice number 10123 dated 15th August 2024, and as indicated in the order paper of 20th August 2024, renders the subsequent proceedings constitutionally invalid. E, a declaration that the respondent's decision to uphold the resolution of the County Assembly of Meru leading to the removal of the petitioner from office by way of impeachment was unconstitutional and a violation of the petitioner's entitlement to the rule of law in light of the principles of sub judice, double jeopardy, and contempt of court. F, a declaration that the respondent's impugned resolution made on 21st August 2024 was founded on grounds that lacked the legally established threshold for removal of a governor by way of impeachment. G, a declaration that Section 33, subsection 8 of the County Government Act is unconstitutional in as far as it allows the reintroduction of the same charges which previously failed to result into the removal of a governor at the expiry of 3 months. Viso amounts to double jeopardy and is a clear contravention of Article 50, Clause 2, Paragraph O of the Constitution, which states that a person shall not be tried for an offense in respect of an act or omission for which the accused person has previously been acquitted or convicted. H, a declaration that the Senate, in its evaluation of the impeachment proceedings before it, fails to properly assess each of the specified grounds and determine if they collectively or individually constitute gross violation of the Constitution, warranting the removal from office by impeachment of the governor. Hence, the resolution of 21st August 2024 does not meet the threshold for impeachment set out under Article 181, Clause 1 of the Constitution. Hence, the same be and is hereby set aside. An order of certiorari to remove into this honorable court and quash the decision and/or resolution of the Senate made on 21st August 2024, resolving to remove the petitioner from office by way of impeachment. An order setting aside Gazette Notice number 10351, volume CXX V1 number 130, dated 20th August 2024, published on 21st August 2024, communicating the decision and/or resolution of the Senate to remove the petitioner from office by way of impeachment. And finally, K, costs of this petition be provided for. Background. Following the general elections held on 8th of August 2022, the petitioner was duly elected and sworn in as the governor of Meru County. The petitioner has faced a series of impeachment motions by the County Assembly of Meru, with a motion dated 31st July 2024 receiving an affirmative vote by the 5th interested party on 8th August 2024, which was forwarded to the Senate on the 9th August 2024, pursuant to Article 181 of the Constitution, as read together with Section 33 of the County Government Act. The respondent convened a special sitting of the Senate on 14th August 2024 to consider the notice of motion on the establishment of a special committee to investigate the proposed removal of the petitioner from office by way of impeachment. The notice of motion was not passed, and instead, the Senate determined that the matter would be canvassed before the Committee of the Whole House, with the Senate sitting in plenary. On 19th and 20th August 2024, the Senate heard the matter, with the County Assembly and the Governor presenting their respective cases. At the conclusion of hearing, the Senate voted on the matter, and it passed a resolution affirming the decision of the County Assembly and removing the petitioner from office by way of impeachment. By way of a Gazette notice dated 20th August 2024 and published on 21st August 2024, the respondent, the Speaker of the Senate, gazetted the decision of the Senate to remove the governor from office by way of impeachment pursuant to Article 181 of the Constitution, Section 33 of the County Government Act, and Standing Order 80 of the Senate Standing Orders. On 21st August 2024, the petitioner, being aggrieved by the decision of the Senate, approached the High Court through a petition dated 21st August 2024 and filed on 21st August 2024, and subsequently the amended petition dated 23rd December 2024, which is the basis for consideration in this judgment. On the grounds that the senatorial process violated various constitutional provisions, including the right to a fair hearing, Article 50, public participation, Article 10, the sub judice principle, among other grounds. The petitioner also sought interlocutory relief via a notice of motion application dated 21st August 2024 and filed on the same 21st August 2024, seeking the grant of ex parte and inter partes interim conservatory orders, which this court granted on 21st August 2024 ex parte and confirmed inter partes pursuant to a ruling dated 18th December 2024, pending the hearing and determination of the substantive petition. The petitioner's primary arguments are that the impeachment did not meet the constitutional threshold, that it was conducted in defiance of a valid court order, that it was based on matters already pending before the High Court in Meru, that the process violated the principle of public participation, and that she was denied a fair hearing. The ruling of this court, dated and delivered on 18th December 2024, granted the interlocutory relief for a period of 120 days only, and on 20th December 2024, this court issued comprehensive directions on the schedule for the hearing and determination of the matter, including the issuance of a judgment date being 14th March 2025, which fell within that 120-day period. The petitioner, having been granted leave to file and serve an amended petition, and interested parties having been joined by the court so as to give all concerned parties an opportunity to be heard, filed and served the same, and responses to the amended petition were also filed and exchanged by the respondent and the interested parties. The matter was canvassed by way of written submissions, with the parties filing written submissions in support of or in opposition of the petitioner's amended petition dated 22nd December 2024 as follows. I'll not, in the interest of time, I'll not go through the various filings. Highlighting of written submissions was held on diverse dates as follows. The petition and those in support of the amended petition on 21st February 2025 and 24th February 2025. The respondent and those opposed to the amended petition on 24th February 2025 and 26th February 2025. Positions of the parties. The petitioner, Honorable Kawira Mwangaza, challenges the impeachment process before the Senate only within the amended petition dated 23rd December 2024. The petitioner has made clear that the ambit of the amended petition before this court is limited to the actions and decisions of the Senate, of the respondent and the Senate, with a substantive challenge to the actions and decisions of the County Assembly being a matter that is being canvassed in another petition filed before the High Court sitting in Meru High Court Constitutional and Human Rights Petition number E013 of 2024, which is still pending before that court and is awaiting full hearing and determination. The petitioner's grievances before this court and in this amended petition are thus limited only to the actions, omissions, and decisions of the Senate in the Senate's consideration and determination of the motion received by the Senate from the County Assembly that culminated in the impugned vote and resolution of the Senate made on 21st August 2024. The petitioner asserts that the impeachment was not only procedurally flawed, but also unconstitutional. She contends that several breaches of her fundamental rights, as enshrined in the Constitution of Kenya, occurred throughout the impeachment process before the Senate. Those breaches include violations of her right to fair hearing, the subversion of court orders, the illegal handling of sub judice matters. The petitioner also argues that the actions by the Senate in considering the motion by the County Assembly were in direct contravention of both national laws and judicial precedents that govern impeachment procedures. At the heart of the amended petition is the claim that her removal was tainted by legal irregularities and thus must be declared null and void. The petitioner asserts that the High Court has jurisdiction to hear this matter based on Articles 165, 3b and d of the Constitution of Kenya. According to these provisions, the High Court has the mandate to determine whether any action by state organ, in this case the Senate, is in violation of the Constitution. The petitioner emphasizes that this case revolves around the interpretation and application of constitutional rights, such as the right to a fair hearing and the right to hold public office, which falls squarely within the High Court's jurisdiction. Additionally, she invokes Article 23, Clause 1, which grants the High Court authority to issue orders for the enforcement of the Bill of Rights. The petitioner also argues that judicial review powers under Article 23, Clause 3, Paragraph F provide the court with the authority to quash any unconstitutional proceedings or decisions that infringe upon her rights, as the Senate was acting as a quasi-judicial body and thus is amenable to the supervisory jurisdiction of the High Court pursuant to Article 165, Clause 6 of the Constitution. The petitioner further holds that the respondent, the Speaker of the Senate, is a proper party capable of being sued in these proceedings. Referencing Martin Nyaga Wambora versus the Speaker of the Senate and 5 others, where the Speaker of the Senate was deemed a proper party capable of being sued, since the Speaker played a direct role in presiding over the impeachment process and was responsible for ensuring procedural compliance, the petitioner underscores that the respondent was capable of mounting and advancing a substantive defense on behalf of the Senate, as evidenced from the respondent's filings in this matter. In addition to the respondent having a direct role in the unconstitutionalities and illegalities with which she is aggrieved. The petitioner emphasizes that the Speaker of the Senate permitted the introduction and continuation of the impeachment process before the Senate, which then proceeded to hear and determine the matter, despite the issuance and pendency of conservatory orders by the High Court sitting at Meru. Those orders, which were granted in response to the petitioner's application, ordered a halt to the impeachment process, and thus the Speaker of the Senate and the Senate were in violation of a court order when the Senate heard and determined the motion laid before the Senate. The petitioner contends that this defiance of court orders is not merely a procedural misstep, but a direct violation of the rule of law and judicial authority. The fact that the respondent, despite being aware of the Meru High Court's ruling dated, and the orders therein, chose to permit the Senate to proceed is, in the mind of a petitioner, a clear and determinative violation of the Constitution, which renders all subsequent actions and decisions of the Senate null and void. To buttress this argument, the petitioner has drawn the attention of this court to the Meru High Court's ruling on contempt of court, which was delivered on 13th February 2025, in which it confirmed that the County Assembly, its Speaker and the mover of the motion were found to have acted in contempt of court for having introduced a fresh impeachment motion, which is the impeachment motion that was heard and determined by the Senate. Turning to the sub judice rule argument, the petitioner argues that several issues that formed the basis of the impeachment charges, such as the employment dispute involving, I'll not name the parties, were already pending in courts of competent jurisdiction. These issues were thus sub judice in the mind of the petitioner, meaning they were under active judicial consideration, and thus their discussion in the Senate was unlawful. The petitioner contends that both Standing Orders 90 of the County Assembly and Standing Order 103 of the Senate clearly prohibit such discussions, as they could potentially prejudice the fair determination of the cases before the courts. Despite this, the petitioner argues that Senate proceeded to discuss and to vote on matters that were legally restricted, thus breaching the sub judice rule. The petitioner argues that the Speaker of the Senate failed to make a ruling on the issue of sub judice when it was raised, which further compounded the violation of procedural fairness. This action, to the petitioner's mind, is a gross violation of the constitutional doctrine of separation of powers, as the Senate was discussing and determining matters pending in courts of law, thus usurping judicial authority from those courts. The petitioner relies on several legal precedents to support her case. She cites the Central Bank of Kenya versus Ratilal Automobiles Limited and Omega Enterprises versus KTDC, which assert that actions taken in defiance of court orders are null and void. These rulings reinforce the petitioner's argument that the impeachment process conducted in violation of court orders cannot stand. The petitioner also invokes the Judicial Service Commission versus Speaker of the National Assembly 2013, which held that contemptuous acts, regardless of whether the contemnor was aware of the court order, are automatically invalid. Based on these precedents, the petitioner calls for the court to declare the impeachment process a nullity, quash the Gazette notice that formalized her removal, and declare the relevant provisions of the County Governments Act unconstitutional. The petitioner also seeks a permanent injunction to prevent any further impeachment proceedings on the same grounds, arguing that such proceedings would be fundamentally flawed and illegal. The petitioner argues that the impeachment process itself violated her right to a fair hearing as guaranteed by Article 50 of the Constitution. She asserts that the proceedings in the Senate were marred by chaos, disorder, and an overall lack of procedural fairness. The petitioner describes how, during the Senate's impeachment debate of 20th August 2024, the proceedings were halted multiple times, and the live media coverage was abruptly stopped. Moreover, the petitioner claims that the time allocated for debate was insufficient, with each senator only given 3 minutes to present their views, which was grossly inadequate given the gravity of the matter. The petitioner's closing remarks were also limited to only 2 minutes, during which she was not even able to give her statement due to the ongoing disruptions. Excuse me. Furthermore, the petitioner highlights that the impeachment motion was rushed, with crucial procedural steps ignored, such as adequate debate and an opportunity for questions and clarifications. These actions created an environment where the petitioner could not adequately defend herself, thus breaching her constitutional right to be heard fairly. The petitioner emphasizes that the conduct of the Senate on that night rendered the impeachment process a mockery of justice and were indicative of a preconceived decision, a violation of her right to fair hearing before a fair and independent quasi-judicial body. The petitioner also argues that the impeachment process was fraught with procedural irregularities, which were acknowledged by some senators after the fact. Several senators, in media statements and parliamentary sessions, admitted that the impeachment was unfair, unprocedural, and invalid. The petitioner argues that these admissions lay bare, by admission, the flawed nature of the process that unfolded before the Senate. The petitioner points out that despite these admissions, no remedial actions were taken by the Senate or the Speaker to address the admitted mistakes. The petitioner cites instances where senators expressed regret over the process, including during the impeachment of the Deputy President on 9th October 2024, where the flaws in the petitioner's impeachment were acknowledged and stated as lessons to be learned for the Deputy Presidential impeachment and also for future proceedings. Despite these acknowledgements, the petitioner argues, having been admitted by members of the Senate, can only lead this court to a finding that indeed the process before the Senate with respect to her impeachment was unconstitutional. The petitioner has also attacked the canvassing of charges that had been previously determined in her favor by the Senate during previous impeachment proceedings against her before the Senate. In addition to arguing that this violates her constitutional protection against double jeopardy on a factual basis, the petitioner also argues that Section 33, subsection 8 of the County Governments Act is unconstitutional because it violates the right against double jeopardy as provided under Article 50, Clause 2, Paragraph O of the Constitution. The petitioner asserts that this provision allows for the removal of a governor through impeachment based on issues that have already been adjudicated by the Senate or matters that had formed the basis for previous impeachment motions by the Senate, and it violates the constitutional protection against both double jeopardy and also fair hearing. In conclusion, the petitioner argues that the impeachment process before the Senate was marred by a series of constitutional violations, procedural defects, and contempt of court. The petitioner asserts that the actions of the Senate and the County Assembly were not only unfair but also illegal, rendering the entire impeachment process null and void. She emphasizes that the conservatory orders, sub judice violations, and denial of fair hearing resulted in a miscarriage of justice. The petitioner further contends that the Senate acted in bad faith by continuing with the impeachment despite clear judicial directives. Given these circumstances, the petitioner urges this court to quash the impeachment process, declare it unconstitutional, and uphold her constitutional rights to due process and a fair hearing. The petitioner's position rested with a plea to this court to uphold the letter and the spirit of the Constitution and to find that the electoral mandate bestowed upon a governor can only be extinguished through a Senate process that is free, fair, procedurally sound, and undertaken with utmost fidelity to the Constitution and the rule of law. Respondent's position. The respondent argues that the court's jurisdiction is limited when reviewing legislative action unless a clear constitutional violation occurs. They reference Isaiah B. Watt Kangwonyi versus IEBC 2018, which reaffirmed the presumption of constitutionality for legislative actions. The respondent asserts that the impeachment process against the governor of Meru was conducted in strict adherence to the law. Article 181 of the Constitution and Section 33 of the County Government Act outline the grounds and procedure for impeachment, and the respondent contends those provisions were strictly adhered to. The Senate, exercising its mandate under Article 96, followed the due process as prescribed, ensuring procedural compliance and constitutional validity. Additionally, the respondent argues that the Senate sufficiently evaluated the grounds presented and found them substantiated, citing specific instances of gross violation of the law, misconduct, and abuse of office. The respondent submits that impeachment does not require proving every charge beyond a reasonable doubt, as it is a constitutional accountability mechanism, not a criminal trial. Referencing the Court of Appeals decision in Kioko versus Clark, Nairobi City County Assembly and 11 others, 2022, where the appellate court affirmed that the governor can be impeached if at least one of the charges is sufficiently substantiated, the respondent argues that the substance of the charges were proved and the court should not interfere with the same. The respondent maintains that there was no valid court order preventing the Senate from proceeding with the impeachment. The respondent argues that the ruling relied upon by the petitioner related to a previous motion and not the motion that ultimately resulted in the governor's removal. The respondent clarifies that the court order issued by the High Court sitting in Meru applied to an earlier impeachment motion dated 17th July 2024, while the impeachment proceedings in question were based on a subsequent motion dated 31st July 2024. As such, there was no valid court order prohibiting the Senate's actions. In buttressing this argument, the respondent asserts that the petitioner failed to raise a proper preliminary objection before the House on that point. This position was supported by Mike Sokombuvu Gideon Kioko versus Clark, Nairobi City County Assembly, and others, 2021, where the court ruled that procedural objections must be raised appropriately before legislative bodies, which the respondent argues the petitioner failed to do. Thus, the respondent argues that neither the Speaker nor the House can be faulted on this limb, as the petitioner herself failed to appropriately move the Senate for it to determine the question. The respondent submits that the impeachment proceedings were conducted in accordance with the standing orders of the Senate. The Speaker provided necessary notifications and scheduled hearings which allowed both the Governor and the County Assembly to participate in the process. The Governor was granted an opportunity to respond to allegations and was represented by legal counsel, negating claims of procedural unfairness. The respondent insists that the Governor was accorded a fair hearing throughout the process. She was given an opportunity to respond to the allegations, was represented by legal counsel, and she had the chance to cross-examine witnesses. The respondent argues that the Governor was given an opportunity to make closing remarks but declined to do so. The argument that she was denied the right to be heard is therefore unfounded, since she was fully represented by legal counsel who made statements on her behalf. The respondent cited Sonko v. County Assembly of Nairobi and 11 others, Supra, where the Supreme Court held that procedural requirements for impeachment are met, including proper notice, evidence presentation, and legal presentation, the decision is sound. The respondent justifies the decision to limit the debate on impeachment motion to 3 minutes per senator by arguing that this limitation was approved by the Senate in accordance with its standing orders, 111 of the Senate standing orders, which allow the House to impose such limits and guides how impeachment trials are conducted. The respondent adds that the motion to limit the debate was duly voted upon and passed by a majority of 31 to 9, making it a legitimate procedural decision and did not violate any constitutional provisions and is in accordance with established rules. the Speaker's decisions regarding procedural matters, including limitation of debate, were legally sound. The Respondent references Uzalendo Institute for Leadership and Democracy versus Attorney General and another, 2021, where the court upheld parliamentary autonomy in regulating its internal procedures and argues that this court cannot interfere with the internal regulation of the proceedings of the Senate. The Respondent also submits that the voting process in the Senate was conducted in strict compliance with standing orders. Senators voted electronically, with some manually casting their votes in accordance with procedural rules. The outcome of the vote reflected the will of the majority. The Respondent further contends that parliamentary proceedings are governed by established rules, and no evidence was adduced by the petitioner to demonstrate any disorder affected the validity of the vote. The Respondent justifies the Speaker's decision not to adjourn the impeachment proceedings despite alleged disorder on this basis. They cited Erskine-May's Treatise 2011, which states that the Speaker has discretion to determine whether disorder warrants adjournment, and the Respondent argues this is a matter over which the court has no jurisdiction in determining. The Respondent opposes the petitioner's claim that Section 33, subsection 8 of the County Governments Act contravenes Article 50, Clause 2, Paragraph O of the Constitution, which prohibits double jeopardy. They state that impeachment is a political process separate from criminal proceedings, and thus Article 52(o) does not apply since it governs criminal trials and not political accountability processes such as impeachment. That provision, to the Respondent's mind, is necessary to uphold governmental and leadership accountability, and the Respondent cites Hastings versus United States, 1992, where a judge was impeached despite prior acquittal in a criminal trial, and it was held that impeachment is a separate political process from criminal proceedings and does not fall within the ambit of double jeopardy protections. The Respondent highlights the laws enacted by Parliament enjoy a presumption of constitutionality. In Isaiah Biwot Kangoni versus IBC and another, Supra, the court held that courts should only declare a law unconstitutional if it clearly contravenes express constitutional provisions, which is not the case with Section 33, subsection 8 of the County Governments Act. The Respondent cites Article 117, Clause 1 of the Constitution and Section 12 of the Parliamentary Powers and Privileges Act to argue that legislative proceedings are protected from judicial interference. Referring to the case of Apollo Mboya versus Attorney General and others, 2018, where it was reaffirmed that parliamentary debates and resolutions cannot be challenged in court unless there is clear evidence of unconstitutionality, the Respondent argues that no such basis has been laid in the present case. The Respondent also argues that the doctrine of separation of powers requires that courts should not interfere in the internal workings of Parliament unless there is a clear violation of the Constitution. Citing the Supreme Court in Justice Kariuki Mate and another versus Martin Nyaga Wambora and another, 2017, which emphasized that judicial restraint is necessary when dealing with matters constitutionally assigned to other arms of government. The Respondent challenges the probative value of the petitioner's evidence, including social media posts and newspaper articles, arguing that they constitute hearsay and thus were inadmissible for failing to meet the requirements of the Evidence Act. The Respondent, relying on IEBC versus National Super Alliance, NASA Kenya, and 6 others, 2017, submits that such materials constitute hearsay unless verified by their authors, which the Respondent asserts was not done in this case. Additionally, Section 106, capital B of the Evidence Act sets strict conditions for the admissibility of electronic evidence, which the petitioner fails to meet as per the Respondent. The Respondent argues that the impeachment decision was reached after full deliberation and was supported by evidence. The Respondent cites the Sonko decision, where it was established that where due process is followed, the court should not overturn the Senate's decision simply because the impeached official disagrees with the outcome. The respondent also argues that the amended petition is incurably defective due to the failure to enjoin the Senate as a party. The respondent contends that the Speaker was not a proper party to sue, as he is an ex-officio member of the House with no vote in any of the impugned matters. The respondent points out that the impugned decision and resolution were taken by the Senate and not by the Speaker, and further that the adverse prayers sought relate to actions and decisions of the Senate as a deliberative body exercising its voting discretion. And it is trite law that adverse orders cannot be sought against a party who has not been sued and is not participating in the proceedings. The respondent further notes that the petitioner had ample opportunity to cure this defect when granted leave to amend the petition, but she did not sue the Senate. Since the Senate as an institution made the decision to remove the governor, it is only that body that could properly respond to the claims raised and not its Speaker. The respondent, in canvassing this limb of its defense, points out that in the Meru High Court matter, number E013 of 2024, the County Assembly was sued by the petitioner, and not by the petitioner that the legislative chamber must be sued in order for adverse orders to be sought against it. The respondent asserts that the orders sought by the petitioner, including the nullification of the impeachment, are untenable because the process followed the law strictly, and the petitioner is in essence raising minor procedural lapses that do not go to the root of the matter and the substantive finding by the Senate. Adding that the petitioner cannot benefit from claims of procedural violations that she neither contested to or failed to challenge at the appropriate time, the respondent contends that the petitioner is clutching at straws in a feeble attempt at escaping the logical outcome of a just and fair constitutional process that found her liable for gross violations of both the Constitution and statute law. Finally, the respondent contended that the impeachment was not politically motivated or discriminatory, nor was it a preconceived decision. They argue it followed established legal frameworks and cited Bhavana Patel Mandalaya versus Chetan Arun Solanki 2021, where the court emphasized that evidentiary requirements must be met for claims of bias to succeed. The respondent concludes by urging this court to dismiss the amended petition in its entirety, arguing that the impeachment process was lawful, that the petitioner was accorded due process, and that the claims made in the amended petition are without merit. The respondent urges the court not to act in substantive merit review of whether the Senate ought to have affirmed or dismissed the charges against the petitioner, but rather only limit itself to whether the law was followed in the process, which the respondent emphatically affirms was the case. The Senate acted within its constitutional and legal mandate. The petitioner was granted a fair hearing, and the impeachment process met the required legal standards. Therefore, the order sought by the petitioner should not be granted. The first, second, and seventh interested parties' position supporting the amended petition. The seventh interested parties' reply and written submissions were struck out by the court due to improper commissioning of the replying affidavit, which meant there was no underlying foundation for the interested parties' written submissions. However, it fully supported those of the petitioner and the first and second interested parties in support. The first, second, and seventh interested parties fully associated themselves with the petitioner's case and supported the amended petition wholeheartedly. In terms of fresh ground covered, the first interested party, the Council of Governors, argues that the court should uphold the sanctity of impeachment and not affirm a process that was marred by irregularities. The Council of Governors' position was that the present case is indicative of a worrying trend in which impeachment has become watered down and the bar for it has become too low. Additionally, the first interested party faulted the Senate for conducting the voting on a day that was not gazetted as an official sitting date, which renders the entire process unlawful in its eyes. To the Council's mind, the manner in which the impeachment was conducted raises fundamental questions about whether due process was followed, and if not rectified, it sets a dangerous precedent for future impeachments. The first interested party asserts that adherence to constitutional and statutory provisions is paramount in such weighty matters that directly affect the sovereign right of Kenyans to elect and be served by a governor of their choice. The second interested party, FIDA Kenya, highlights that the petitioner's fundamental constitutional rights were violated throughout the impeachment process, and this was part of a larger challenge faced by women in political leadership positions. The second interested party echoed the averments by the petitioner in her supporting affidavit that she was subjected to gender discrimination contrary to Article 27 of the Constitution, and the petitioner's right to equal treatment and equal protection of the law were manifestly violated by the Senate in its proceedings. Article 50 of the Constitution guarantees every person the right to a fair hearing, yet the petitioner was denied this right when she was not allowed to present closing arguments before the Senate. This deprivation goes against established legal practices and fairness standards, and this was submitted by the second interested parties. On the key constitutional requirements for impeachment, which is public participation, the second interested party notes that the process did not meet the constitutional standards required under the law. The second interested party also raises serious concerns about gender discrimination in the impeachment process. The petitioner, being a female governor in a society which both the petitioner and the second interested party stated has strong patriarchal structures, has been subjected to relentless political persecution. They observed that the impeachment marks the fifth attempt to remove the petitioner from office, suggesting a pattern of targeted victimization rather than a genuine accountability process. FIDA Kenya argues that women in leadership positions, particularly in highly patriarchal societies like Meru, face undue scrutiny and hostility. The petitioner's case is reminiscent of historical gender-based political exclusion, where women are not given opportunities to lead. The impeachment proceedings in the Senate, to their mind, were conducted in a manner that reinforces societal biases against female leadership, discouraging other women from pursuing political careers. The second interested party also highlights that the petitioner has been subjected to multiple impeachment attempts based on the same set of allegations. The second interested party in particular proposes several legal remedies, including the nullification of the impeachment, an order reinstating the petitioner, and an injunction preventing further impeachment attempts on the same grounds. They also recommend legal reforms to protect governors from politically motivated impeachments. The Senate's role in impeachment should also be clearly defined, and adherence to due process enshrined. They urge this court to be alive to the reality behind the impeachment of the petitioner in the Senate and establish through this judgment a precedent that strengthens constitutional safeguards against abuse of the process of impeachment and accords protections for discriminatory actions brought under the guise of legitimate impeachments. The positions of the third, fourth, fifth, and sixth interested parties in opposition of the amended petition. In addition to treading the same ground as the respondent and fully supporting the respondent's opposition to the amended petition, the third, fourth, fifth, and sixth interested parties oppose the petitioner's case and assert that the amended petition dated 23rd December 2024 fails to meet the constitutional standard of precision set out in Anarita Karimi Njeru versus Republic 1979. According to the legal precedent established in that seminal case, a constitutional petition must explicitly outline the specific rights alleged to have been violated and provide substantive evidence to support those claims. However, they contend the petitioner has broadly referred to Articles 1, 93 and 38 of the Constitution without clearly demonstrating how these provisions have been contravened. Moreover, to their mind, the amended petition makes sweeping allegations that entire articles of the Constitution have been violated without detailing specific breaches. The fifth interested party in particular refutes the petitioner's argument that impeachment undermines the will of the electorate, stating that democratic governance is not just about elections but also about accountability throughout a leader's tenure. The constitutional framework ensures that an elected leader does not act with impunity simply because they were elected by the people. It argues that allowing a governor to remain in office despite evidence of misconduct would be an affront to the principles of good governance and constitutionalism. Additionally, the fifth interested party stresses that impeachment does not automatically translate to an unfair or politically motivated process, as the law provides clear guidelines for its execution. The removal of a leader through impeachment, therefore, serves as a corrective mechanism that protects public trust in governance and prevents abuse of power, and thus, this court should only intervene where there is a clear violation of the Constitution, which there is none to their minds in this case. The sixth interested party contends that this court should not rely on the ruling dated and issued on 13th February 2025, in which the sixth interested party and others were found to be in contempt of court for introducing the fresh impeachment motion that led to the Senate's impugned resolution. The interested parties, collectively opposed, urge that this court finds that it is not bound by the Meru High Court's decision and to independently analyze the question of whether there was a valid order capable of barring the Senate from proceeding to hear and determine the motion before it. So I go through the analysis of the law that the parties opposed have given. In the interest of time, I will skip to their collective conclusion. The interested parties in opposition warn that granting the petitioner's prayers would set a dangerous precedent where public officials use the judiciary to obstruct legitimate governance and accountability processes. They further assert that any alleged procedural irregularities in the impeachment process do not justify overturning the entire process as long as the substantive grounds for removal were legally sound. The court, they argue, must uphold the rule of law and ensure that democratic institutions can function without undue interference from the judiciary. The interested parties who opposed the amended petition therefore urge the court to dismiss the amended petition with costs. Issues for determination. Having considered the amended petition, the responses thereto, both in support and in opposition, the written submissions filed by the parties, the court has identified the following 7 issues for determination. A. Whether the respondent was a proper party and whether the order sought against the Senate can issue. B. Whether the Senate impeachment was invalid for being in defiance of a valid court order. C. Whether the impeachment was invalid for being predicated on matters sub judice. D. Whether Section 33, subsection 8 of the County Governments Act contravenes Article 50, Clause 2, Paragraph O of the Constitution and is therefore unconstitutional. E. Whether the threshold for public participation in the impeachment process was met. F. Whether the threshold for impeachment was met. And finally, G. Whether the Senate impeachment was invalid due to violation of the right to a fair hearing. On the first issue, whether the respondent is a proper party and whether the order sought against the Senate can issue, the questions of whether the Speaker of the Senate is the proper respondent in this petition and whether the court can issue orders against the Senate are critical procedural questions that go to the root of the amended petition before this court. The Speaker of the Senate was sued in his official capacity, meaning that he is not being personally held liable, but is representing the institution of the Senate. This distinction is crucial because under constitutional and parliamentary practice, office holders such as the Speaker act as agents of the institutions they serve. The Speaker presided over the impeachment proceedings and played a fundamental role in guiding the Senate during the process, albeit a role that did not involve voting. The Speaker of the Senate did not personally vote or contribute to the impugned outcome. Rather, the Senate's decision was made collectively by senators. It is clear to my mind that the Speaker of the Senate, as a respondent, understood the capacity in which he was sued in this matter. It is clear from the responses and written submissions filed by the respondent that the Speaker of the Senate was able to articulate a strong defense on behalf of the Senate. Further, the Speaker of the Senate's responses were in the form of affidavits deposed by the Clerk of the Senate, a clear indication that the respondent understood his role in this matter, as well as the need to articulate a position on behalf of the Senate rather than one limited to its Speaker only. The Constitution of Kenya, Protection of Rights and Fundamental Freedoms, Practice and Procedure Rules, commonly known as the Mutunga Rules, at Rule 5, Paragraph D2, provides that a constitutional petition shall not be defeated solely because of misjoinder or non-joinder of parties. That rule operationalizes the constitutional edict contained in Article 159, Clause 2, Paragraph D, which directs that courts shall administer justice without undue regard to procedural technicalities. Even if it were argued that the Senate should have been named directly instead of the Speaker, the fact remains that the Speaker advanced a strong defense for the Senate, meaning that no injustice or unfairness arises from this procedural issue. Courts have ruled in previous cases, such as Trusted Society of Human Rights Alliance versus AG and others, 2012, that a petition should not be dismissed simply because of a misdescription of parties, as long as the correct institution has been represented and has had the opportunity to respond. Additionally, courts in Kenya have consistently emphasized the importance of focusing on substantive justice rather than dismissing cases based on minor procedural lapses. In Mumo Matemu versus Trusted Society of Human Rights Alliance and 5 others, 2013, the Court of Appeal upheld the principle that courts should avoid dismissing petitions based on technicalities, especially where fundamental constitutional questions are raised. Similarly, in Mwangi Stephen Murithi versus Attorney General, 1995, KLR, the court stressed that procedural defects should not override the core objective of determining whether a party's rights have been violated. If the court were to find that the impeachment of the petitioner was unconstitutional, it would not be logical to refuse to issue the necessary remedies simply because of a misdescription of the respondent. The Speaker has fully and ably articulated the defense of the Senate, meaning that the Senate has had its day in court, and the issuance of orders against the Speaker would have the same legal effect as orders against the Senate itself. Flowing on from this, I am satisfied that the amended petition can properly seek adverse orders against the Senate, since the Speaker of the Senate is the respondent in this matter. Our constitutional order has long since abandoned the obsession with procedure and technicalities that bedeviled constitutional litigation in former times. The Senate was ably represented and suffered no prejudice from its non-joinder, as the Speaker of the Senate was the respondent herein, and the orders sought against the Senate were vehemently opposed by its Speaker on behalf of the august House. Consequently, it is the finding of this court that the Speaker of the Senate was a proper party in these proceedings, and that office's joinder as a respondent within the context of the amended petition before this court nevertheless enabled the Senate to raise and argue a strong defense, and the adverse order sought against the Senate can properly lie against the Senate despite its direct non-joinder if the amended petition were to succeed. The second issue, whether the Senate impeachment was invalid for being in defiance of a valid court order. Paragraph 80. Court orders are not whimsical suggestions feebly whispered by judicial bodies in the vain hope that there will be compliance. On the contrary, court orders are the thunderous roar of the people of Kenya, giving voice to and in full exercise of their sovereign majesty, demanding obedience with the Constitution and the other laws that they, the people of Kenya, have crafted and agreed to be bound by and to bind all others within the jurisdiction. In that regard, violation of a court order is an extremely serious issue that goes to the heart of judicial authority and the vibrancy of our constitutional order. This court must tread carefully, as the order that the Speaker of the Senate and the Senate as a whole are alleged to have violated is an order of the High Court of Kenya sitting at Meru in a matter that is still pending before that court. That Meru High Court matter is between the petitioner herein as the petitioner therein and almost all of the interested parties opposed to the amended petition. And it concerns the actions, omissions, and decisions of the County Assembly of Meru with regard to the impeachment motions dated or filed against the petitioner in the month of July, and in particular, one motion which gave rise to the impugned Senate resolution that is the subject of these proceedings. There are many elements to this issue for determination, all of which but one are either still pending before the High Court sitting at Meru or are the subject of ongoing proceedings before the Court of Appeal. The sole element that this court can safely carve out from the rest is the question of whether the Speaker of the Senate and the Senate, not being parties in those Meru proceedings, could have reasonably been expected to understand the Meru High Court's stated intention that the orders in the ruling dated 24th July 2024 by Kasan J applied to any future motions by the County Assembly, such as the one dated 31st July 2024, which is the subject of the Senate's consideration and impugned decision, in addition to the one referenced in the ruling being the motion dated 15th July 2024. That position was articulated clearly by the High Court sitting in Meru in its contempt of court ruling dated 13th February 2025. But that ruling came long after the Senate's impugned actions and decisions. Looking at the ruling and the orders therein, it would be reasonable to conclude that the Senate and its Speaker may not have immediately discerned that meaning from the wording of the ruling. Without being a party to those proceedings, I am satisfied that the Speaker and the Senate could not have been reasonably expected to appreciate the intention of the Meru High Court, and thus they cannot be faulted for proceeding as they did. I am equally satisfied that the petitioner herein failed to properly advance the issue of the court order before the Senate. I agree with the respondent that a letter to the Speaker of the Senate is not the proper way to raise a preliminary objection as per the Senate's internal rules, any more than a letter to a judicial officer would be a proper way to raise a preliminary objection before a court. While it can be argued that the Senate should have sought judicial clarification before proceeding with impeachment, I find that it would have been better for the petitioner, a party in those Meru High Court proceedings, to have been proactive and placed that material clarification before the Senate, in addition to properly moving the Senate as per its internal rules. The petitioner ought to have extracted the order from the ruling of Kasan J and formally placed it before the Senate, or filed the necessary process before the High Court sitting in Meru to create an express situation where the Senate could not have proceeded without expressly violating a court order of which they had direct knowledge. By not doing so, the petitioner created a gap in which the benefit of doubt must favor the respondent and the Senate. Additionally, this court notes that the Court of Appeal at Nyeri, in a ruling dated 5th March 2025 in civil application number E020 of 2025 as consolidated with civil application number E021 of 2025 has ordered as follows. I will not read the order. The Court of Appeal is now seized with a wider question of whether there was a valid Meru High Court order capable of being violated and resulting in contempt of court. All this court can safely determine is that the Senate's resolution cannot be justly quashed on the basis of an alleged violation of the Meru High Court's orders in circumstances where the ruling and orders dated and issued on 24th July 2024 by the High Court sitting in Meru were likely unclear to persons not being parties to those proceedings, such as the respondent herein, and whose interpretation may be successfully challenged in the Court of Appeal, and whose interpretation and application in August of 2024 is still the subject of court proceedings in other fora in March of 2025. On that basis, the respondent and the Senate should be and are given the benefit of the doubt, and I find that the petition has not established to the required legal standard that the respondent and the Senate violated a valid court order for the purposes of these proceedings. Paragraph 88. That being said, it would be remiss of this court not to speak plainly on what would have been the outcome had the petitioner laid that basis. Simply, the amended petition would have succeeded on that ground alone. If it was settled or open to be settled by this court that the impeachment motion brought by the before and by the fifth interested party that gave rise to the impugned Senate resolution was undertaken in violation of a court order, this court would have had no hesitation in quashing the Senate resolution on that basis alone, because the substratum, the County Assembly's motion, was invalid on having been undertaken in defiance of a court order. Even a good faith action by the respondent and the Senate is liable to be quashed if the underlying and preceding actions by a county assembly are found to have been illegal and thus invalid. Whether the Senate impeachment was invalid for being predicated on matters sub judice. Paragraph 89. The doctrine of sub judice is an important legal principle that prevents courts and other adjudicatory bodies from deliberating on matters that are actively pending before another court of law or adjudicatory body. The petitioner argues that the Senate's impeachment process was invalid because it was based on matters that were already pending before the High Court in Meru and other courts, thus violating this rule. The purpose of sub judice is to ensure that judicial decisions are made without interference or parallel proceedings that could lead to conflicting judgments. The sub judice principle is well established in Kenyan law and is expressly recognized under Standing Order 92 of the Senate Standing Orders. Standing Order 92 states that senators shall not refer to matters that are pending in court if doing so would prejudice the fair determination of the case. However, the standing order also includes an exemption, allowing the Senate to proceed if the Speaker determines that the matter is of overriding public interest. This means while the doctrine of sub judice generally applies in the Senate, it is not absolute, particularly in cases where the Senate is exercising its constitutional oversight functions. Courts have also provided guidance on the application of sub judice. In Kenya National Commission on Human Rights versus Attorney General 2020, the court stated that the sub judice rule is meant to protect judicial proceedings from undue influence and ensure that courts, rather than legislative bodies, are the final arbiters of legal disputes. However, in Republic versus Chief Magistrate Milimani and two others, ex parte Tusker Mattresses Limited and three others, 2013, the court clarified that sub judice only applies when the matters being adjudicated are substantially similar and the second forum's decision could prejudice the ongoing court case. Therefore, the critical question is whether the Senate's deliberations were substantially the same as the issues pending in the High Court in Meru and other courts, and whether the impeachment proceedings prejudiced or would likely prejudice the fair adjudication of the pending cases. Despite the petitioner's reliance on the sub judice rule, the Senate was not necessarily barred from proceeding with impeachment. The respondent argues that the Senate Speaker was within his powers to allow the process to continue under the public interest exception in Standing Order 92. Furthermore, courts have consistently ruled that parliamentary proceedings, including impeachment, should not be halted simply because there is a pending court case unless there is a direct risk of judicial interference. Neither the petitioner nor any of the interested parties supporting the amended petition have been able to demonstrate a sufficient likelihood that there would be, or there would likely be, a significant negative effect from the Senate having considered matters that were the subject of pending court cases. A Senate resolution that touches in whole or in part on a subject matter that is pending in courts of law is, of course, not binding on those courts. They are free to independently arrive at the same or an opposite finding. To successfully invoke sub judice, a petitioner must show more than the concurrent consideration of the same subject matter. Rather, the petitioner must show a real, current, or likely, or future threat to his or her rights and or the rule of law and the proper administration of justice by that concurrent consideration of the same subject matter. To hold otherwise, as a general rule, would be to subordinate the Senate's exercise of its constitutional mandate with regard to impeachment to judicial processes whose progression and timelines may be uncertain. The doctrine of separation of powers must be a two-way street. Unless in clear cases where there is an identifiable threat to constitutional rights, the rule of law and or the proper administration of justice coupled with a significant harm or the likelihood of significant harm, Parliament's discussion of a matter pending before a court of law should not result in the invalidation of any consequent action it takes. Parliament should, of course, exercise great restraint in deliberating matters that are pending before the courts, and should do so in a limited manner, and should do so very rarely and only in the most pressing of instances. Parliament is not just any other body. It is a collection of elected and nominated representatives of the people of Kenya, sitting in two houses that are deliberative chambers with immense gravitas and the ability to shape and sway public opinion. I note that the petitioner has articulated a similar sub judice challenge in the Meru High Court matter, directed at the proceedings before and by the County Assembly. This court's findings on sub judice are limited to the four corners of this amended petition and the impugned proceedings and resolution of the Senate, and this court makes no finding on that sub judice element as it applied to the County Assembly's proceedings. In conclusion, under this limb, it is the finding of this court that the amended petition has not successfully laid the required basis for interference by this court with the resolution of the Senate on the grounds of sub judice. Next, whether Section 33, subsection 8 of the Constitution of the County Governments Act contravenes Article 50, Clause 2, Paragraph O of the Constitution and is therefore unconstitutional. At this juncture, it is proper that this court comments on the petitioner's choice of filing and arguing two distinct High Court constitutional petitions concurrently. One in Meru against the County Assembly's actions and another in Milimani, Nairobi against the Senate's impeachment process. The respondent and the interested parties who oppose the amended petition have unsuccessfully argued that the present proceedings are sub judice those pending before the Meru High Court, and they are unsuccessful in that regard because even from their own filings it is clear that they appreciated the distinction between the two cases. With regard to Section 33, subsection 8 of the County Governments Act and its alleged unconstitutionality, the petitioner has conceded that an identical prayer has been advanced in the petition pending before the High Court sitting at Meru. Given that the Meru matter was filed first in time, it is fit and proper that it be the one to determine this issue, notwithstanding that the parties herein all extensively submitted on this limb of the amended petition. By filing two distinct petitions in two different stations, the petitioner has created an uncomfortable situation where, in essence, there is a possibility of the petitioner enjoying two bites at the cherry, as it were. Perhaps more importantly, the petitioner's choice of crafting two distinct petitions with minimal overlap, such that consolidation would not be automatic, has had the consequence of denying a single court a bird's-eye view of the entirety of the process, from the inception at the County Assembly to the Senate resolution, and thus forcing two High Court stations to tread carefully so as not to stray into the other's case. To be clear, this was not forum shopping, but rather it was clever lawyering, where the petitioner's counsel identified a loophole that they could use to the benefit of their client. By drafting and filing a petition before this court in which all the allegations were limited to the Senate stage, and by only suing the Senate Speaker, perhaps fully aware that the County Assembly and its officers would be forced to join the proceedings through applications for joinder, the petitioner has created a situation where she now has two opportunities for success rather than just one. As discussed earlier under the limb of the court order and whether it was violated, this court is limited by the amended petition to only the Senate stage aspect of that limb, with the petitioner still having another opportunity in the County Assembly stage challenge of the same limb, which is pending before the High Court in Meru. As we continue to fine-tune the practice and process of litigation in the High Court on the subject matter of gubernatorial impeachments, this is certainly a loophole that must be firmly closed by the courts in future impeachments if a similar situation were to arise. This would not only make adjudication of the dispute more wholesome and comprehensive, but it would also ensure that all the petitioner's grievances are laid before a single court, which would be able to take a holistic view of the matter rather than being constrained to a more limited view. Therefore, while the constitutional validity of Section 33, subsection 8 of the County Government Act poses legitimate legal questions, both in favor of and in opposition of its constitutionality, this court declines to determine the same within this judgment, as the same is pending before the Meru High Court in a related matter which was filed earlier in time. Whether the threshold for public participation was met in the impeachment process. The issue of whether the threshold for public participation was met in the impeachment process is central to the petitioner's argument that the impeachment proceedings were unlawful. Public participation is a constitutional requirement under Article 10, Clause 2, Paragraph A, and Article 196(1)B of the Constitution of Kenya 2010, which mandate inclusive and meaningful citizen engagement in government decision-making, including legislative processes such as impeachment. However, public participation in impeachment proceedings primarily occurs at the County Assembly level rather than at the Senate level, since the County Assembly is the initiating body that formulates and debates the impeachment motion before transmitting it to the Senate for the final determination. The petitioner contends that the public participation process was inadequate or manipulated, thereby rendering the entire impeachment invalid. However, the respondent and the interested parties who support the respondent maintain that public participation was conducted in compliance with legal requirements, and any challenge to its inadequacy should be directed at the County Assembly rather than the Senate. Once more, this court is treading delicately so as not to stray into the province of a petition that is pending before the High Court in another station, and thus refrains from an in-depth analysis and determination of this issue, despite the parties having canvassed it at great length. This situation, as stated earlier, is a direct consequence of the drafting and filing choices made by the petitioner, which resulted in two live but distinct petitions pending before the High Court sitting at Meru and sitting at Milimani, Nairobi. Given that the petitioner has not sought adverse orders against the County Assembly, the court finds it procedurally improper to determine this issue in the present petition, as it is already being addressed in a separate case before the Meru High Court, in which the matter of public participation is at the core of the petitioner's grievance against the County Assembly. For the purposes of this amended petition, it is the finding of this court that the amended petition has not shown a correlation between its allegations on public participation and justiciable grounds against the respondent and the Senate within the four corners of the amended petition that is before this court. The next issue, whether the threshold for impeachment of the petitioner was met. The question of whether the threshold for impeachment was met revolves around two key legal considerations: whether the charges against the petitioner constituted valid grounds for removal under the Constitution, and whether the High Court should conduct a merit review or a process review of the impeachment decision. The petitioner and the interested parties who are in support of the amended petition contend that the allegations against her did not amount to gross misconduct, abuse of office, or gross violation of the Constitution, as required under Article 181, Clause 1 of the Constitution. On the other hand, the respondent and the interested parties who oppose the amended petition argue that the charges presented before the Senate were serious and substantiated, thus meeting the legal standard for impeachment. The Constitution of Kenya 2010 under Article 181 Clause 1 states that a governor may be removed for office for 1. Gross violation of the Constitution or any other law. 2. There being serious reasons to believe the governor has committed a crime under national or international law. 3. Abuse of office or gross misconduct. Or 4. Physical or mental incapacity to perform the functions of the office. These requirements are mirrored in Section 33 of the County Governments Act, which outlines the procedure for impeachment, requiring an initial resolution by the County Assembly followed by a Senate hearing and vote. The Senate is tasked with evaluating the sufficiency of the charges and determining whether the evidence meets the constitutional threshold. Courts have consistently ruled that impeachment is not a purely political process, but one that requires objective and verifiable evidence of wrongdoing. Several landmark cases have clarified the legal threshold for impeachment, reinforcing the principle that impeachment must be based on substantive proof of serious wrongdoing. In Martin Nyaga Wamboro versus Speaker of the Senate and others 2014, the Court of Appeal held that impeachment must be based on evidence of gross violations of the law, not on minor procedural errors or political differences. The decision emphasized that governance mistakes or administrative inefficiencies do not automatically amount to gross misconduct warranting removal from office. Similarly, in Governor Ferdinand Waititu versus County Assembly of Kiambu and the Senate 2020, the High Court ruled that impeachment should not be misused as a tool for political maneuvering, but must be based on serious and substantiated allegations. In another seminal case, Mike Sonko versus County Assembly of Nairobi and Senate 2021, the Supreme Court clarified that the threshold for impeachment requires proof of gross misconduct and significant breaches of the law. In the current case, the Senate reviewed the allegations against the petition and found that they met the threshold for gross misconduct under Article 181(1), meaning that the charges were serious enough to warrant removal. Applying this principle, if the Senate found the allegations against the petitioner to be serious, backed by evidence, and meeting the constitutional standard, the impeachment should stand. A crucial legal question in this case is whether the High Court should conduct a merit review, reassessing the correctness of the charges and the evidence, or a process review, assessing whether due process was followed. Courts have consistently ruled that judicial review of impeachment should focus on ensuring procedural compliance rather than assessing the merits of the charges. In the Supreme Court case of Peter Munya, the Apex Court emphasized that judicial intervention in constitutional processes should be limited and should focus on procedural fairness rather than the correctness of legislative decisions. Similarly, in Wambora versus Speaker of the Senate and others, Supra, the Court of Appeal held that the High Court's role in impeachment cases is to ensure that the process followed the legal and constitutional requirements rather than substituting its own judgment on the allegations. The Supreme Court further reinforced this position in Sonko 2021, where it ruled that the Senate and County Assembly have the constitutional authority to determine impeachment matters, and courts should only intervene where there are clear violations of due process. Applying these principles to the present case, the High Court is not required to assess whether the Senate made the right decision, but should only determine whether the procedure followed was fair and constitutional. A proper reading of these decisions in light of the Constitution requires that this court can only engage in a merit review of the decision of the Senate if the decision of the Senate on the applicable law and/or evidence was so profoundly incorrect that no reasonable quasi-judicial body properly applying its mind to the law and the facts would have arrived at that conclusion, notwithstanding the procedural compliance of the process. This court is satisfied that the charges laid before the Senate and which were considered by the chamber in favor of impeachment were of a nature that meets the requirements of Article 181, Clause 1 of the Constitution, and the petitioner has not shown that the Senate's analysis of the applicable law and evidence was so profoundly incorrect that no reasonable quasi-judicial body properly applying its mind to the law and the facts would have arrived at that conclusion, and thus warranting interference by this court. With regard to the procedural and due process probity of the Senate's processes, this court notes that the unique circumstances of this case and the manner in which the parties canvassed the question of fair hearing require that the same be analyzed separately and not as part of an omnibus procedural and due process examination. In that regard, while the court finds that the procedural and due process boxes were ticked in the Senate, the question of whether there was a substantive fair hearing in the Senate shall be dealt with separately and below. The right to a fair hearing is a fundamental constitutional guarantee enshrined under Article 50 of the Constitution of Kenya 2010. The petitioner claims that her impeachment was invalid due to the alleged violation of her right to a fair hearing during the Senate proceedings, a position supported by the first, second, and seventh interested parties, but strenuously opposed by the Respondent and the third, fourth, fifth, and sixth interested parties. The relative positions of each of the parties on this issue were extensively set out earlier in this judgment, and thus there is no need to repeat them here. From those extensive articulations of their relative positions, it is clear that the issue of fair hearing has 5 distinct sub-issues, being A, whether the petitioner was afforded sufficient opportunity to present her case; B, whether the senators were given adequate time and opportunity to consider the matter; C, what is the probative value of the statements both during and after the fact by a section of the senators; so it should be 6. D, whether there were disruptions or disorder of a nature as to deny the petitioner a fair hearing; E, whether in the Senate proceedings the petitioner was subjected to discriminatory or unfair treatment; and F, whether there is evidence that there was a preconceived outcome and thus the hearing before the Senate was a sham. The question of whether the petitioner was afforded a sufficient opportunity to present her case requires an examination of both the individual milestones in the hearing process as well as an overall view of the entire Senate process. In both aspects, the petitioner has provided evidence in the form of the Hansard that shows that the procedural milestones were met and they were of a sufficiently proper nature as to insulate them from an adverse finding by this court. The petitioner may disagree with the overall outcome of those steps and how they connected as a whole, but the petitioner has not shown a deficiency in each or in all as a collective that would require this court's interference. Another aspect of the petitioner's argument is that she was only given 2 minutes to make a personal statement at the conclusion of the proceedings and that she did not get the chance to deliver it. However, the court's review of the Hansard and video recordings indicates that the Speaker of the Senate granted her the opportunity to speak. The uncertainty regarding whether she remained silent by choice or whether there was a technical issue with her microphone does not alter the fact that she was given the opportunity to address the Senate. Moreover, her legal counsel did not raise any objections during the proceedings, either regarding the time allocation or any technical difficulties. Courts have previously held that a party who fails to object to a procedural issue at the appropriate stage cannot later claim to have been denied a fair hearing. In Republic versus Public Procurement Administrative Review Board and another ex parte GIB Africa Limited and another 2012, the court ruled that a party who fails to raise an objection at the appropriate stage of proceedings cannot later claim to have been denied a fair hearing. Since the petitioner did not object at the time, and there is no evidence that she was prevented from speaking, the claim that her right to a personal statement was violated lacks merit. Similarly, the petitioner has failed to show that the senators did not have sufficient time and opportunity to consider the matter. The respondents and the interested parties who oppose the amended petition are correct in stating that it is not for this court to impose its own view on how much time should have been allocated or how the matters should have been laid before the senators, but rather to see if they met the basic requirements of a fair hearing. I note that the impugned resolution process commenced substantively with the Senate's decision not to have a special committee hear the matter and prepare a report which would be voted on by the House. Excuse me. But rather have the entire Senate sit as a committee of the whole House and vote as the special constitutional procedures applicable require. This, to my mind, meant that each senator who participated had sufficient time and opportunity to consider the matter. One of the petitioner's key complaints is the senators were only allocated 3 minutes each to debate the impeachment motion, which she argues was an insufficient amount of time. The petitioner has presented signing-in forms suggesting that some of the senators may have objected to the short debate time, as well as statements made thereafter about an alleged admission of insufficient time and opportunity by some of the senators. However, for such an argument to hold legal weight, the petitioner should have ensured that the senators who felt constrained by the debate time had sworn affidavits confirming that they were unable to effectively express their views and consider the matter and file them in these proceedings. Courts have consistently held that procedural fairness should be analyzed holistically rather than focusing on isolated aspects of a process. In JSC versus Mbalu Mutava and another 2015, the Court of Appeal emphasized this point. Applying this principle, this court finds that the limited debate time did not compromise the fairness of the proceedings, as the impeachment process did not involve a committee report requiring lengthy deliberations. Additionally, senators had access to the impeachment report beforehand and were given an opportunity to ask questions and deliberate before the proceedings. Therefore, the claim that the short debate time rendered the hearing unfair is not substantiated. The petitioner also argues that the impeachment proceedings were chaotic and disruptive, thereby affecting the fairness of the process. However, an examination of the petitioner's own video evidence, as well as the official Hansard, does not support the claim that the chaos was of such a nature that it negatively impacted the fairness of the hearing. Courts have previously ruled that not every procedural irregularity renders a process unfair. Only those that materially affect the fairness of the proceedings are considered grounds for judicial intervention. In Dry Associates Limited versus Capital Markets Authority and another 2012, the court held that not every procedural irregularity is fatal. Only those that cause substantial prejudice to a party's rights will justify the setting aside of a decision. In this case, the court has determined that while the proceedings may have been politically charged, there was no significant disruption that prevented the petitioner from presenting her case effectively. Therefore, the argument that procedural chaos rendered the hearing unfair is not supported by sufficient evidence. On the penultimate sub-issue, the question of gender discrimination and denial of equal treatment under the law, there can be no denying that, zooming out from the present case, we remain a nation that regrettably has not made the strides towards gender equality and promotion of the participation of women in governance that a nation of our democratic credentials should have made. There can be no denying the fact that despite all our other successes in constitutional implementation and deepening our democracy, the area of fostering inclusivity and diversity in political representation remains one in which we need to do much better as a country. It is difficult for women to successfully demonstrate gender bias and denial of equal protection of the law in the governance arena, because more often than not, these biases and discriminatory treatments are not brought out starkly by those who perpetrate them, but rather they are subtle yet significant actions, decisions, and omissions that create an unequal playing field for women. That being said, the petitioner and the second interested party have not particularized this complaint with specific reference to the Senate's proceedings or shown an aspect or element of the proceedings before the Senate that show gender bias against the petitioner. Perhaps this is because, while we have a wider problem with gender bias, the Senate conducted its proceedings strictly without any form of gender bias against the petitioner. Had the contrary been demonstrated to the required standard, then on this sub-issue of 7 main issues, this court would have had no hesitation in quashing the Senate's resolution. The final claims raised by the petitioner relate to the dating of the Gazette notice and the clerk of the Senate's letter, as well as the speed with which the Senate conducted the impeachment vote. The Senate contends that the Gazette notice and the clerk's letter were both dated 20th August 2024, despite the vote taking place on 21st August 2024, which she argues is a proof of a predetermined decision. Under Section 107 of the Evidence Act, the burden of proof is on the petitioner to establish that these documents indicate a premeditated decision rather than being the result of a typographical or clerical error or even a good faith mistake. The petitioner failed to provide evidence to refute the simpler explanation that the date discrepancy was a minor administrative oversight rather than the much more serious claim of a proof of a rigged or predetermined process. Similarly, the claim that the Senate rushed to conclude the impeachment or sat on non-gazetted days has not met the required threshold, as there is no requirement that the impeachment proceedings must last a specific duration. Courts have previously held that the expedited process is not inherently unconstitutional unless it is demonstrated that it deprived a party of an opportunity to be heard. In Republic versus Speaker of Nairobi City County Assembly and another ex parte Evans Kidero, 2017, the court held that an expedited process is not inherently unconstitutional unless it is shown that it deprived a party of an opportunity to be heard. The petitioner has not demonstrated how the Senate's action of expediting the hearing and determination of the matter before it deprived her of an opportunity to be heard or was indicative of a preconceived outcome. An analysis of all the applicable evidence demonstrates that the petitioner was accorded all the procedural safeguards necessary for a fair hearing, including the opportunity to present evidence, respond to both allegations as well as questions from the senators, oppose the county assembly's position, and make a final statement. Excuse me. The Senate proceedings followed standard parliamentary procedure, incorporating an opening statement, presentation of evidence, an opportunity for senators to ask questions, and a closing statement. The court has assessed the totality of the impeachment process and found that the petitioner was given ample opportunity to present her case and respond to allegations leveled against her. While the petitioner has pointed out certain aspects of the proceedings that she considers unfair, such as limited debate time, the opportunity to make a personal statement, the alleged chaotic nature of the proceedings, the timing of official communications, and the perceived haste in concluding the impeachment, none of these claims have been substantiated sufficiently to warrant a finding that her fair hearing rights were violated. Therefore, the Senate's impeachment process was procedurally sound and does not warrant judicial intervention on grounds of unfair hearing. Conclusion. Paragraph 133. Gubernatorial impeachment is an invaluable safeguard against impunity and abuse of office that must be jealously protected. It must not be allowed to become an avenue for fighting political proxy wars or resurrecting the ballot box contestations that were determined by the electorate when it chose a particular candidate to hold the office of governor. In that regard, the Senate, as a national legislative body that is able to rise above the din of the county-level gladiatorial arena, is uniquely placed to safeguard the sanctity, probity, and vitality of this very important accountability measure. Watering down impeachment, lowering its bar too low, or allowing it to become a facade that masks hidden political interests runs the risk of Kenyans losing confidence in the process. Interventions by the courts come further down the impeachment path, and thus it is the duty of the primary duty bearers, the concerned county assembly and thereafter the Senate, to ensure that impeachment remains as constitutionally envisaged. Turning back to the present case, and in light of the foregoing, the inescapable conclusion is that the amended petition dated 23rd December 2024 has not met the required legal threshold for success. As outlined above, certain aspects of what was laid before this court and submitted on extensively by the parties has been reserved for determination in another forum, a situation occasioned by the petitioner's choice to split her grievances into two petitions pending before two different high court stations. What this court could safely determine without falling into sub judice was insufficiently articulated for finding in favor of the petitioner. While ordinarily courts would follow the event, in the circumstances of this matter, I am satisfied that it is fit, just, and proper that each party bears its own costs. Before I rest my quill by penning the disposition and final orders, I must thank the learned counsel for the parties in this matter for their industry, adherence to strict and short timelines, and the professional courtesy they extended each other. The breadth of their written submissions and the manner in which they ably highlighted those submissions orally made this court's task of judgment writing a lot easier. I would also like to thank the parties for maintaining decorum while attending court sessions, despite this being a highly emotive and charged matter. Disposition and final orders. Consequently, and for the following reasons, this court finds and determines that A. The amended petition dated 23rd December 2024, which is the subject of the proceedings herein, is found to be without merit and is dismissed accordingly. B. The Gazette notice number 10351 volume CXXV1 number 130 dated 20th August, published on 21st August 2024 and issued by the Respondent, communicating the decision and or resolution of the Senate to remove the petitioner from office as the governor of Meru County by way of impeachment, is affirmed for the purposes of these proceedings. C. Consequent to A and B above, the subsequent constitutional and statutory actions are free to take place as per the applicable timelines. And D. Each party shall bear their own costs. Dated, signed, and delivered in open court on this 14th day of March, 2025. I did, before Councillor Mutuma, before you speak, I did state at the beginning that I would give you hard copies. As I was reading through, I saw one or two spelling mistakes, little double words. I will work on those. It will be uploaded into CTS. You'll have it today, So I'll do that. You'll have it on CTS today. I have signed the hard copy as required by the law with my handwritten corrections of those spelling mistakes. Yes, Counsel Mutuma?
Yes, thank you, Your Lordship, for the judgment. We note the expeditious nature in which the court has been able to dispose of this matter.
Yes.
My instructions, Your Lordship, is that we note from your judgment that a majority of the issues raised in the petition remain unresolved.
Yes.
And have been shelved and reserved for determination by the petition pending in Meru.
Yes.
We are therefore of a strong position that there is need to grant the petitioner an opportunity to have those issues which are the majority heard and determined.
Yes.
And since the court has had the opportunity to hear the issues being canvassed by all parties extensively,
yes,
it will then appreciate the need for the issues, for the very weighty issues to be determined.
Yes.
As such, Your Lordship, my instructions are to humbly request you to grant us temporary relief in whatever nature, but specifically an order of status quo to be maintained in the prevailing period, to allow the petitioner ably prosecute the issues pending before the Meru Court.
Yes.
And secondly, to also consider exercising a right of appeal in the Court of Appeal.
Yes.
This order of status quo, Your Lordship, can be structured in such a manner that it will be time bound with the effect of automatically lapsing should the petitioner not have gotten a relief either from the Meru Court or from the Court of Appeal. We submit, Your Lordship, that there will be absolutely no prejudice on any of the parties if orders of status quo are maintained. In any case, it is the situation that has been prevailing since August 2024. Having that situation maintained for the next few weeks or months will not in any way prejudice the petitioners.
This moment, please repeat the period.
The period, my submission to Your Lordship is that in any case, the status quo has been prevailing since August 2024. There will be no prejudice if that same situation is maintained in the next few weeks, or rather for the next few weeks or months, just to ensure that the very weighty issues that the court has appreciated will have an opportunity to be determined on merit. The contrary is true, Your Lordship, that should an order of status quo not be issued, then effectively, whatever is pending in Meru, whatever is pending in the Court of Appeal, like the court has already noted, is all rendered an academic exercise.
by dint of Article 23, we humbly request the court to issue conservatory orders post-judgment. And to expedite our next move, Your Lordship,
Yes.
we humbly then request the court to direct the Deputy Registrar to supply us with type proceedings in this matter.
Yes.
And a copy of a certified judgment. That is all, Your Lordship.
Ms. Sani?
Yes, thank you, my lord. My lord, we oppose the application for the first reason that this court has identified.
We oppose?
Yes, we oppose the application. My lord, in the judgment, this court has identified that the petitioner's action of approaching two different courts was for this purpose exactly. This application is not to dismiss the respondents from enjoying the fruits of their judgments after this court has started third parties on merit. I know it is not true that there will be no prejudice. The court has found that on merit, the Senate did conduct a proper process within the law.
Yes.
And further suspending that process is not in the interest of justice. It is not in the interest of Article 10. And it is not what is envisaged under Article 181.
Yes.
My lord, the petitioner having been found to be worthy of leaving office pursuant to Article 181, she has remedies in other courts, but at this point, this court is found insufficient. My lord, the Meru court is seized of the matters pending before it, and you have rightly declined to deal with those matters. That court can make appropriate orders concerning this issue. That court can quash any process. They have the power to do that based on the material before them, which is not before you this afternoon. My lord, in the Wajir impeachment case, the court quashed the impeachment and the process proceeded after that. But for this court to be asked to take action based on the matters before the court in Meru is not proper, and it is negating the judgment delivered this morning and further suspending a proper decision of the Senate. My lord, we oppose. Thank you.
Just a moment. So we have quite a number of interested parties. So I will call on one from each side. First interested party, Counsel.
Thank you, my lord.
Yes.
Thank you for the industry that the court has shown in determining this dispute within the timelines that it has slowed down. My lord, we wish to submit to associate ourselves with the application by the petition. With regards to the request for a status quo order, this will enable the parties to ventilate the issues that the court has also be found in the petition have filed in mail.
Yes.
And these interim orders will be able to avoid the disruption of the governance. We also wish to request for time copy of the proceedings as well as the certified copies of the judgment. That is all I'm saying.
Counsel Kirimi.
Thank you, my lord. On behalf of the interested parties who opposed the petition, my lord, first and foremost, to thank you for the good judgment that you delivered. And my lord, on behalf of all my colleagues who appeared before you, and as the senior most counsel perhaps who appeared before you, we are sincerely grateful for the opportunity to canvass the issues we did before you. My lord, so that I won't come again before you.
Yes.
We are also sincerely grateful to yourself for the professional courtesy that you extended to us.
Yes.
My lord, in a specific way, we are very grateful that you found in your heart to forgive us when we did not appear to be proper before you.
Yes.
And we thank you specifically for pushing yourself and ourselves to meet the strict timelines that you set to canvass this petition before you. My lord, turning to the application by Mr. Mutuma, we do oppose the same.
Yes.
First, you are now franked as official. Secondly, my lord, the weighty issues Mr. Mutuma is raising from the bar cannot be raised in an oral application. We would kindly suggest that the petitioner finds it proper to file a formal application before you for urgent consideration and for a formal opportunity to all parties opposed thereto to file a response. Thirdly, Your Lordship, by making any decision that would amount to a stay of the negative orders you have just granted, with all due respect, Your Lordship, you will be sitting on an appeal of your own decision. And my Lord, this court will be making its orders appear inferior to orders of other courts. We urge Your Lordship not to be persuaded at all to grant any orders of status quo. My Lord, fourthly,
yes,
there is grave injustice and prejudice that is going to be suffered by the people of Meru and the voters of whom I represent by an order of status quo or stay or an umpteenth time applied for conservatory order. My Lord, that will be in breach of Article 10 and Article 1 of our Constitution. My Lord, fifthly, we are alive that the petitioner has a right to appeal against the decision. The superior courts may grant orders of stay if they properly seized of that legal mandate. But Your Lord, as far as you're concerned, you've done your work. We kindly ask you not to allow a stay of that decision even for a second. People have never been waiting for this judgment. The court has rendered itself. It's upon all of us as parties to take up our other rights, and the constitutional frameworks and set standards should now take effect. We are established.
thank you. So give me about 5 minutes to write
the card permission will not you.
Yes.
The amount is not published inside. I pay for 5 minutes to not you.
Because we have so many interested parties, if I extend to yourselves, for fairness, I'd have to extend to others. It's a straightforward issue. I think every counsel who walks into a court in this country and beyond has an application for stay in their mind, or how they will attack an application of stay if their side has won. So I'd request that you allow me to give my ruling, and we leave it at that.
form.
So this is my ruling on the oral application. The court has heard and considered the petitioner's application for status quo or stay or interim relief that would maintain the petitioner as the governor of Meru County and stop the consequent actions that the judgment of this court has allowed to take place from being implemented. Learned counsel for the petitioner has argued that the temporary relief Learned counsel for the petitioner has argued that the temporary relief, in whatever form, would allow the petitioner to adequately canvass the pending Meru High Court matter, which in the judgment of this court, a number of issues have been reserved for hearing and determination by that court. Further, Counsel Mutuma submitted that doing so would also allow the petitioner to effectively apply for and exercise her right to appeal to the court above. Counsel Mutuma argues that no party would suffer any prejudice, as in essence the oral application, if granted, would merely maintain and extend the status quo that has obtained from 21st August 2024 for a few more weeks and months. Learned counsel underscored that, on the contrary, not allowing the oral application would result in significant changes in the governance of the county of Meru and would render the Meru High Court matter or any forthcoming appeal academic. In support, Learned counsel for the first interested party, Counsel Lawi, on behalf of all the interested parties supporting the amended petition, echoed the submissions of petitioner's counsel and reinforced the need for a status quo order to allow for a seamless appeal process as well as a seamless hearing and determination of the other matter. Counsel Thanji, Learned counsel for the respondent, opposed the oral application. She observed that the court is now functus official and the petitioner has other avenues in a matter that is still pending, being the Meru High Court matter, or upon appeal. She concluded by noting that the judgment was clear that the Senate's actions and resolution were constitutional, and thus it would not be proper to suspend that action, and also this own court's judgment delivered earlier in today's session. Counsel Kirimi, Learned counsel for the third interested party, and on behalf of all counsel for the interested parties opposed, added and argued that this court cannot stay a negative finding, and the granting of the oral application would amount to this court sitting on appeal of its own decision. Counsel Kirimi argued that stay or interim relief would greatly prejudice the people of Meru, one of which he represents in these proceedings, who have been eagerly awaiting the conclusion of this matter. The grant of the orders sought orally would also prolong the uncertainty in Meru County. He rested by arguing that in any case, it is a weighty application that should be in writing, with all parties being granted time to respond before a decision. I have considered the submissions by Learned counsel and reflected on the matter in light of the unique circumstances of the case and the applicable judicial precedent, and I find that this court is not the appropriate forum for consideration of the grant of stay or the grounds adduced by Learned counsel for the petition. Counsel explicitly referenced other fora that are, to my mind, better placed to consider and apply the injunctive relief sought on the basis of cases filed and pending before them or to be filed before them. I'm also satisfied that the Constitution and statute law provide for subsequent processes that would address any governance challenges that would arise from the operationalization of this judgment delivered a few moments ago. Lastly, I find that neither the petitioner nor the interested parties in support have identified any weighty issue that would or could be a potential error in my judgment just delivered that could form the basis of this court considering if there would be an arguable appeal or a just reason to stay this judgment in the interim. Overall, and noting that Our constitutional order gives the petitioner ample time to seek injunctive relief in other fora, and noting that this has been a prolonged litigation in which the petitioner has enjoyed interim relief since 21st August 2024 with respect to a resolution of the Senate that has been found to be lawful by this court, I decline to grant the interim relief or stay sought orally. Certified copy of judgment and proceedings to be availed on priority. 14th March 2025. So I will work on the slight. Yes, Ms. Tanch, sorry. No.
Thank you, my lord.
Yes.
We appreciate the industry and the time taken.
Counsel Mutuma?
Yes, sir. Thank you, Your Lordship, again for the image. For your time and ruling. We abide by this.
Thank you, Counsel. I will. The only minor errors. Sometimes when you read in your mind, you don't catch these errors. You can only catch them when you read out loud. They are very minor, so you will have this very shortly. Also, there will be a press release that will be communicated. I don't know why my court assistant has looked at me. My court assistant will get the press release, and it will be communicated through the appropriate judicial channels to the media. Before I rise, I'd like to sincerely thank Counsel on all sides for the manner in which you have argued your respective positions. I have been greatly impressed by the depth of your submissions. And even as a judge, I can safely say that I have learned things from reading your submissions and the manner in which you argued your respective cases. I look forward to seeing you all in future matters. Thank you. Have a good day.